Naquan Humphreys.
Spell your last name for me.
Humphrys.
How old are you?
25.
Have you ever been convicted of a felony?
Yes, ma'am.
How many?
4 times.
All right, can you tell me what happened on the date of this incident? Why were you sitting out in the vehicle?
I was sitting in the car waiting on my brother to come out of the hotel room.
When law enforcement approached you, why did you end up running?
I ran because back, like my previous, I had got beaten by the police in handcuffs.
Is that why you ran this time?
Yes, ma'am.
When you ran from the vehicle, did you have anything in your hands?
That's when I had my shirt that was on top of my head.
When you when the officer was behind you, did he ever tase you?
No, ma'am.
Was the officer did you know that the taser had been deployed?
No, I didn't know that. I was already over the fence.
When you ran from the vehicle, besides your shirt, did you have anything else in your hands?
No, ma'am.
When you were there at law enforcement, did you know why he was talking to you? What was going on?
No, man, not really. That's why I know somebody was blowing the horn, so I thought that was the reason why. But I don't know what else the reason for real.
And the vehicle that you were in, that was a vehicle that your brother was using?
Yes, ma'am.
I don't have any other questions, Your Honor.
Thank you.
Could you just give me one moment?
Sure. Okay, thank you. All right, sir, you may return to your seat.
Defense race.
All right. Ladies and gentlemen, this is another stage in the proceedings where we have to take up some legal matters outside of your presence now that both sides have rested their case. So even though you just got back in, I do have to ask you to step back out so I can take care of those legal issues. Remember the rule, don't discuss the case, don't form any opinions, don't do any research. Please be seated. And let the record reflect that the jury has left the courtroom, and I do have in the courtroom all counsel and the defendant. And any motions?
You know, we were renew our motion for judgment of acquittal in this case.
Okay, do you wish to make any further argument?
No, Your Honor, same arguments as before. We don't believe a prima facie case has been made in either charge.
Okay, any response?
Or just the same response I stated before, Steve Brown's position.
All right. The motion will be denied for the same reasons as previous. All inferences would go to the state at this point, and I believe there is sufficient evidence for the jury to consider. Would there be any changes to the jury instructions that we went over?
I don't believe so.
Okay. Wonderful. All right. And how much time does the state request for closing?
You already raised how much time for closing?
Yes, how much time do y'all need for closing?
For the state, probably less than 10 minutes. 15 minutes for the state. Oh, okay.
Yeah, however much time either side needs, whatever the most either side needs, I will give it to both sides.
Yes, Your Honor.
So, you know, however much you need, you just,
20 minutes, Your Honor.
okay. How much time does the defense?
20 minutes, Your Honor.
20 minutes each. And does the state wish to Does anybody wish to have a warning?
Yes, Your Honor.
Okay. And how much, what type of warning would you like?
I would say if there's 5 minutes left.
I mean, honestly, if
I
you're,
don't think we're gonna get to it.
5 is fine, Your Honor.
yeah, honestly though, I mean, if each of you are only needing 20 minutes, I'm not going to cut you off
Thank you.
mid-sentence. If you go over, that's fine.
Thank you, Your Honor.
Sure, I mean, if, when it gets to be an hour, then I start watching the clock, but,
Understood.
yeah, but I'm not gonna,
Understood, Your Honor.
I'm not even gonna interrupt you if,
We appreciate it, ma'am.
yeah. So, does the state wish to reserve a certain amount of time for rebuttal?
Yeah, the 20 minutes, I believe, was included for
Okay,
the rebuttal.
okay. Does anybody need a break before we go forward?
Yes, Your Honor, if we could just have about 5 minutes.
Yes, let's do that.
That's fine.
Sure. In fact, before we take our break, let me ask you this. So how long do you think it will take to go get the copies made? Like, are we gonna,
I'm
I'm
gonna add
assuming
10
they
minutes,
have it
Your
done
Honor.
within the break, I'm assuming.
Yeah, I think Mr. Strauss is down there doing it. I'm gonna go down there and help him while we're on this break. Can I request 10 minutes instead of 5?
sure,
Okay.
absolutely. Yes, I just want to make sure that when y'all finish closing, that we will have the instructions.
Yes.
And I want for both sides to look at the copies, especially the defense, make sure that the copies are correct and that you approve them before we pass them out.
Yes, ma'am.
All right. So we'll be in recess for 10 minutes. I'm just going to stay here and work on something, so, but
Yes, ma'am.
well, I'm going to put the white noise on.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You've been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years,
Okay,
the
so
sweet
let
aroma
me just make our
of the
record.
Crestvew's Coney Islands
We had a
burgers
break,
and hot dogs
and
has
the instructions have been copied in the courtroom. I have both counsel for the state, and I have Ms. Dudley. Thank you. Thank you, and I've been handed,
Where is it? It's like right before page 11. So you might want to rip that one out. Oh, this is in my bag.
It's not in the rest.
Okay.
I don't have an extra blank page in mine.
Just me?
Okay. I have a stapler if anybody needs it. So I've been handed the final instructions, and Ms. Dudley, have you reviewed the final instructions?
Yes, Your Honor, I have.
Any objections or corrections?
No, Your Honor.
Okay, so we have the copies for the jury. I have the verdict form here. Ms. Dudley, you want to come take a look at it and make sure it's agreeable? It's the one that was emailed. Mhm. Okay, all right. Okay. Thank you so much.
Just so you're gonna need to.
Who's gonna help you with that?
So I have an extra set. I have actually, I have 8 sets for the jury. I'm going to count them again. I have 8 sets for the jurors. I have a set for the court reporter that I'll get to the court reporter. I'm going to sign my set and give it to Madam Clerk, and so I have an extra. Does anyone need this extra?
I'll have one from Ms. Gagel.
Sure. All right, and let the record reflect the defendant is present in the courtroom and all counsel. And are both sides ready to proceed with closing?
Yes, Your Honor.
Okay, any other issues I need to take up before we bring the jury back in?
Not that I'm aware of.
All right, so I do need to, actually, I need to speak to Mr. Nielsen.
Your Honor,
Yeah.
before the jury comes back, the state will be approaching the clerk to grab a piece of evidence. So just so you're aware, if I do approach over there.
That's fine.
You need much.
Not a problem. Just make sure that if you're speaking, you're not speaking while you're walking, or the microphone won't pick you up. Okay, I need to say something to Mr. Nielsen. Yes.
10.
No, I just wanted to tell you that, and just so our record is clear, Mr. Nielsen is recording and broadcasting the proceedings. He's a member of the media with permission to be here. He followed all the rules. I'm going to, at some point, be releasing the alternates.
Right.
So I don't want their names to be broadcast.
We had coordinated that before.
I know, and then I messed it up, they were talking about an old trial from before, and I repeated their names at a time I wasn't supposed to.
If you're just saying, I'm going to announce the alternate, that would be my, I'm fine
Okay.
with that.
Well, what I normally say is, this is the part of the trial I like the least.
Yeah.
And I'll say it after I've finished all of the instructions, and then I'll say, now we're at the part of the trial that I like the least. 2 of you are our alternate jurors, and then you'll know it's coming then.
I'll be, that audio will not go out, but I'll be able to hear you, so when you finish doing that, I can go back on.
Okay, that sounds good. Thank you.
Thank you, Judge.
Sure. Okay, are we ready to bring in the jurors? All right, let's bring in the jury. Thank you.
Please stand with her.
Please be seated. Thank you. All right, let the record reflect the presence of the jury, all counsel, and the defendant. And ladies and gentlemen, both sides have rested their case. And we're about to have closing arguments. Then I'll instruct you on the law, and then you'll be able to start your deliberations. I have a preliminary instruction to read to you. Both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid in your understanding of the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. All right, at that point, Ms. Giardina, you may proceed.
Now, would you turn this on so I can...
Yes, would you like the laptop or the document camera?
The laptop, please.
All right, get that going. Okay, it's on the screen.
Your Honor, I'm going to approach the clerk quickly.
Sure.
Your Honor, I'm going to place this on the jury box. If I can approach.
Sure, go ahead. And just so our record is clear, could you please identify that exhibit?
Yes, Your Honor, that is Exhibit 1.
Okay, thank you. All right, whenever you're ready, you may proceed.
Thank you all for your time and attention today. I want you to know how grateful we all are for that. I want to spend some time reviewing the evidence and the facts of this case with you and applying that to the law. So first, I want to go through the charges. On count 1, Malik Humphreys is charged with trafficking in fentanyl more than 28 grams or 28 grams or more. And count 2, resisting an officer without violence. And as we know, the state's burden is beyond a reasonable doubt. So for count 1, trafficking in fentanyl, the state must prove beyond a reasonable doubt that the defendant knowingly possessed the substance, meaning that he knew of the existence of the substance, he exercised control of that substance. The substance was fentanyl, and the fentanyl was 28 grams or more. For count 2, resisting without violence, the state must also prove beyond a reasonable doubt that the defendant resisted Corporal Williams. At the time, Corporal Williams was engaged in the lawful execution of a legal duty, and at the time, the defendant knew Corporal Williams was an officer. Ladies and gentlemen, the defendant was in a vehicle with a backpack that belonged to him. When Corporal Williams initiated contact, the defendant picked up that backpack and ran with it. He ran because he knew exactly what was inside: 66 grams of fentanyl. He had 66 reasons to run. Corporal Williams told you what he saw. He saw that backpack with the defendant in the vehicle. He saw the defendant grab it. He saw the defendant flee with it. He picked up that backpack from the ground right where the defendant jumped over the fence. The backpack wasn't already sitting on the ground. It didn't magically appear by the fence. The defendant took it with him. That behavior matters. Running, holding on to the bag, dropping it. Those are not the actions of someone who has no idea what's in their bag. That is consciousness of guilt. The defendant exercised control of that bag and the drugs that were inside of it. We heard FDLE analyst Stephanie Spiegel. She testified to what the substance was, how she tested it, and how much it weighed. It was fentanyl, a large amount. The weight meets the trafficking threshold under Florida law. The state has proven beyond a reasonable doubt that the defendant knowingly possessed a trafficking amount of fentanyl, 28 grams or more. We also heard that the defendant fled from Corporal Williams, escaping to avoid arrest. That is resisting an officer without violence. He wasn't confused. It wasn't a misunderstanding. Corporal Williams was clearly a law enforcement officer in uniform. The defendant knew that Corporal Williams was a law enforcement officer. Corporal Williams told the defendant to stop, all to which the defendant ignored. He ran because he knew what he had, and he knew what that meant. The state has proven beyond a reasonable doubt that the defendant committed resisting an officer without violence. Members of the jury, the evidence in this case is clear. Malik Humphreys possessed that fentanyl, he ran with it, and he only abandoned it when he had no other option. The law, the facts, and the defendant's own actions all point in one direction. Hold him accountable and return a verdict of guilty. Thank you.
All right, thank you. And defense?
Thank you for your patience and attention. We'll take a little bit more of your time. What we know in this case is this. We know that Deputy Williams made a citizen's contact. He says that into his radio. He doesn't say into his radio, I'm not good at an investigation. He doesn't say, I'm talking to somebody I believe committed a burglary. He says a citizen's contact. At no point does he say that he is conducting an investigation to any crime. And as a matter of fact, he couldn't tell us what crime he could say Mr. Humphreys committed. In order for him to detain him, there must be a crime that he has committed. He admitted on the stand a consensual encounter with a citizen. They don't have to talk to him. They don't have to talk to him. Which Mr. Humphreys did not have to talk to him. Simply because law enforcement made contact doesn't mean he has to communicate with him, talk to him, and listen to him. That's why the jury instruction says a legal duty. Not just that law enforcement has made contact and tells him something. Corporal Williams also testified that he told Mr. Humphrey to step out of the vehicle. He never says that. He never takes any step to detain him at all. Actually, when Mr. Humphreys goes to get out of the vehicle, he tells him to stop, so he gets out and he goes the other way. Mr. Humphreys testified that the reason why he ran was his prior experience with law enforcement where he was beat by law enforcement.
Or approach?
Permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Island's burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 8.
So Mr. Humphreys didn't run from law enforcement because there was a consciousness of guilt. You can watch that video. You don't see any bag in that car, in that truck. You don't see any bag on the defendant when he's running. Also, Corporal Williams testified that I tased him, and as he was going over the fence, he dropped the bag. You watch that video, you don't ever see where he actually tases him. He deploys his taser, but at that point, he's deploying the taser at the fence. But he testified that he deployed his taser. Once the taser hit Mr. Humphreys, then Mr. Humphreys dropped the bag. That's what he says. And that is not on that video either. Mr. Humphreys has testified he did have something in his hand. It was a shirt that he had on top of his head when he ran, and you can see that shirt where it was dropped when he ran. If you watch the video, you can see by the time Corporal Williams gets to the fence, no one's there. So the state just stated that the reason why Mr. Humphreys, in their words, abandoned the backpack was because he had no choice. Mr. Humphreys was already over the fence where nobody was on him. Corporal Williams was not right behind him. If he had a bag, the bag could have been over the fence with him. The state's position was, as they told you, the last thing they said was he abandoned it because he had no choice. That's not the case. He never had it. And even in the video, Corporal Williams even says for other stuff, he's like, oh, what's that over there? He saw something else on the other side of the fence. We don't know where that came from, but he saw something else in that area. What we know from FDLE is that one pill tested positive for fentanyl. That's what we know. We know that multiple pills out there are blue and round. We know that multiple pills that are blue and round also have M30 on it. We know that you won't know what the pill is until you test it. And the only testimony we have today was that they tested one pill. And then that pill tested positive for fentanyl. When you look at the evidence in this case, the state has not met their burden. The officer was not conducting a legal duty. He wasn't. He can't tell us what crime he was committing. He could have easily ran the tag when he pulled up. It's not, and he even admitted, Mr. Humphrey's job to prove he didn't commit a crime. Suspicion of suspicious behavior is not a crime. He wasn't arrested for suspicious behavior. He's not arrested for a burglary. He's not arrested for any of those things because that's not what was occurring. The officer literally made contact as a citizen's contact to ask questions, but he doesn't have to answer any questions. He never asked him to get out. He never tries to detain him till after he starts running. He didn't submit anything for DNA or fingerprints, nothing at all. And actually, he touched everything with our gloves on, contaminating the evidence. We would ask, based on this, we do not believe the state has proven the charge beyond to the exclusion of all reasonable doubt, and ask that you turn the verdict of not guilty. Thank you.
Thank you. And State?
Yes, Your Honor.
Do you want the laptop?
Yes, please, Your Honor.
Okay, the screen is on.
So, ladies and gentlemen, Corporal Williams testified to the suspicious activity that he observed. He was investigating a possible vehicle burglary. He didn't get to finish that investigation because the defendant fled. But what did become investigated was trafficking in fentanyl. Corporal Williams testified that he was conducting the investigation. The defendant was lawfully detained for that investigation. And again, he fled before the corporal had a chance to ask any further questions. Remember Corporal Williams' testimony, he was initially the only officer on scene, so he couldn't walk behind the vehicle. The corporal did testify he deployed his taser. He deployed that taser when Malik Humphreys went to jump over the fence, and that bag wound up on the floor. He saw Malik Humphreys the entire time. Malik Humphreys ran away from him. Corporal Williams was behind him. He stated today, he testified that he only lost sight of him for approximately 1 second. The corporal was there. He witnessed it. His body cam shows most of it. Here, what I showed earlier is Mr. Humphreys running from Corporal Williams with what appears to be a bag in his hand. All of the pills that were sent to FDLE are virtually identical. A random pill is selected to test. Is it reasonable to think that only one in there would be a fentanyl pill when they're all the same? That's not reasonable. All of those pills constituted a trafficking amount of fentanyl. It was just over 66 grams. Thank you for your time.
All right, please pass out the instructions. Thank you. Did every juror get a set of instructions? Does anyone not have a set of instructions? Okay. Ladies and gentlemen, I'm about to read the instructions to you. You may read along with me if you wish, but you're not required to, and you can take these instructions into the jury room with you to refer to while you deliberate. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Malik Naquan Humphreys, the defendant in this case, has been accused of the crimes of, count 1, trafficking in fentanyl 28 grams or more, and count 2, resisting an officer without violence. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of trafficking in fentanyl, the state must prove the following 3 elements beyond a reasonable doubt. Malik Naquan Humphreys knowingly possessed a substance. The substance was fentanyl. The fentanyl was 28 grams or more. To prove Malik Naquan Humphreys knowingly possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Malik Naquan Humphreys had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, two or more persons may possess a substance. Lack of knowledge of the illicit nature of a controlled substance is a defense to trafficking in fentanyl. You may, but are not required, to infer that Malik Naquan Humphreys was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. If you are convinced beyond a reasonable doubt that Malik Naquan Humphreys knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of trafficking in fentanyl. If you have a reasonable doubt on the question of whether Malik Naquan Humphreys knew of the illicit nature of the controlled substance, you should find him not guilty of trafficking in fentanyl. If you find the defendant guilty of trafficking in fentanyl, you must further determine by your verdict whether the state has further proved beyond a reasonable doubt that A, the fentanyl weighed 28 grams or more, or B, the fentanyl weighed 14 grams or more but less than 28 grams, or C, the fentanyl weighed 4 grams or more but less than 14 grams. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crimes of trafficking in fentanyl are possession with intent to sell or deliver a controlled substance and possession of a controlled substance. The next instruction is about the lesser included offense of possession with intent to sell or deliver a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of possession with intent to sell or deliver a controlled substance, the state must prove the following 3 elements beyond a reasonable doubt. Malik Naquan Humphreys possessed with intent to sell or deliver a certain substance. The substance was fentanyl, and Malik Naquan Humphreys had knowledge of the presence of the substance. Sell means to transfer or deliver something to another person in exchange for money or something of value, or a promise of money or something of value. Deliver or delivery means the actual, constructive, or attempted transfer from one person to another of a controlled substance, whether or not there is an agency relationship. To prove Malik Naquan Humphreys possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Malik Naquan Humphreys had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, 2 or more persons may possess a substance. Lack of knowledge of the illicit nature of a controlled substance is a defense to possession with intent to sell or deliver a controlled substance. You may, but are not required, to infer that Malik Naquan Humphreys was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. You may, but are not required, to infer that a person who sells a controlled substance knows of its illicit nature. If you are convinced beyond a reasonable doubt that Malik Naquan Humphreys knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of possession with intent to sell or deliver a controlled substance. If you have a reasonable doubt on the question of whether Malik Naquan Humphreys knew of the illicit nature of the controlled substance, you should find him not guilty of possession with intent to sell or deliver a controlled substance. The next instruction pertains to the lesser included offense of possession of a controlled substance. Certain drugs and chemical substances are by law known as controlled substances. Fentanyl is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following two elements beyond a reasonable doubt. Malik Naquan Humphreys possessed a substance. And number two, the substance was fentanyl. To prove Malik Naquan Humphreys possessed a substance, the state must prove beyond a reasonable doubt that he A, knew of the existence of the substance, and B, intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Malik Naquan Humphreys had direct personal power to control the substance or the present ability to direct its control by another. Lack of knowledge of the illicit nature of a controlled substance is a defense to possession of a controlled substance. You may but are not required to infer that Malik Naquan Humphreys was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. If you are convinced beyond a reasonable doubt that Malik Naquan Humphreys knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of possession of a controlled substance. If you have a reasonable doubt on the question of whether Malik Naquan Humphreys knew of the illicit nature of the controlled substance, you should find him not guilty of possession of a controlled substance. The next instruction has to do with count 2, resisting an officer without violence. To prove the crime of resisting an officer without violence, the state must prove the following 4 elements beyond a reasonable doubt. Malik Naquan Humphreys resisted Corporal Lance Williams. At the time, Corporal Lance Williams was engaged in the lawful execution of a legal duty. At the time, Corporal Lance Williams was an officer. At the time, Malik Naquan Humphreys knew Corporal Lance Williams was an officer. The next instruction is titled Plea of Not Guilty, Reasonable Doubt, and Burden of Proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. The next instruction is titled Weighing the Evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The next instruction is titled Defendant's Statements. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to, whether, when the defendant made the statement, he had been threatened to get him to make the statement, and whether anyone had promised him anything to get him to make the statement. If you conclude the defendant made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. The next instruction is titled Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. The next instruction is a cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. The next instruction is about the verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. And this is the verdict form that I'm holding, and it will be sent to the jury room with you. I'm going to read it to you. It has the name of the case, State of Florida versus Malik Naquan Humphreys. It has the court. We're in the circuit court for Okaloosa County, Florida. It has the case number and the division. And it says verdict. There are two questions on the verdict form with some subparts. Question number 1. We, the jury, find as follows as to count 1 of the information. And you're to check only one box under question 1. The options are A, the defendant is guilty of trafficking in fentanyl 28 grams or more. Then the form gives you an instruction that if the defendant is not guilty of the main charge, then you proceed to the lesser included offenses. These are the other options under question 1. B, the defendant is guilty of trafficking in fentanyl 14 grams or more but less than 28 grams. C, the defendant is guilty of trafficking in fentanyl 4 grams or more but less than 14 grams. D, the defendant is guilty of possession of fentanyl with intent to sell or deliver fentanyl. E, the defendant is guilty of possession of fentanyl. Or F, the defendant is not guilty. Then there's the second question on the verdict form. We, the jury, find as follows as to count 2 of the information, and then you check only one box under question 2. And they are A, the defendant is guilty of resisting an officer without violence, or B, the defendant is not guilty. Then underneath, after you've finished filling out the form, there's a place to date the form, and the foreperson will sign the form, and then you will let court security know that you've reached a verdict, and you'll bring that into the jury room or into the courtroom. So I'm going to pick back up reading the instructions, and the title to the next instruction is Single Defendant, Multiple Counts. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. They don't mean a separate form. Both of the crimes charged are on the same form. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The next instruction is titled Submitting Case to Jury. In just a few moments, you will be taken to the jury room by court security. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to court security. Many of you have cell phones, tablets, laptops, or other electronic devices that are hopefully all in the jury room and not in the courtroom. These rules do not allow you to bring your phones or any of those types of electronic devices into the jury room once you start to deliberate. What you will do, even though the instruction says leave those devices on your seats where they will be guarded, what we're going to do is court security will collect your phones, put them in a basket, and lock them up. So they will be secured while you're deliberating, and then once the case is over, they'll be returned to you. If you need to communicate with me, send a note through court security. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. If you wish to see exhibits 1 and or 2, please request that in writing. Those exhibits can't go back into the room with you, so we'll bring you back out and you can examine those exhibits as long as you wish. Exhibits 3 and 4 will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Are there any objections to the instructions as read? State? No, Your Honor. Defense? No, Your Honor. Ladies and gentlemen, this is the part of the trial that I like the least. 2 of you are alternates. We chose 2. Okay, let the record reflect that the alternate jurors have left the courtroom. Ladies and gentlemen, the rules are so strict that once the alternates have been discharged, I can't let you go into the jury room with the alternates at the same time. So I have to wait until they get their things and they have left the jury room before I can let you go in. And court security will let me know when we get the all clear. Okay, so thank you. So what will happen is we're going to let you go in the jury room to begin your deliberations. The exhibits, the ones that can come in with you, are going to be brought in along with the verdict form, which I'm handing to Deputy Torres now. And you can take your notes with you and the instructions, and then also that looks like the box for the cell phones. So once you get in there, court security is going to collect your cell phones and lock them up and keep them secure while you're deliberating. Okay? All right. You may now begin your deliberations. Thank you. Yes.
I know you just mentioned cell phones, but also these smartwatches.
Oh, yes, if you have an Apple Watch or smartwatch, that will be collected as well. Thank you.